Guys. Hey, guys. All right. That was my bow impression. Did you enjoy it? Well, good morning. It's a balmy 65 degrees out. Lovely weather for a 4:15 walk. Actually, it's about 4:30 now. Maybe a little bit later. I just watched Ed's part 1 of his poster 7. I need to get down to the law library to look up the 39 CFR and 41 CFR, see if those actually have any litigation based solely on filming or photography. I always mean to do it, but then I get to the law library and I get lost in the wonderful world of law, and I find myself researching a case where someone sued their doctor over hemorrhoids or something. You know, it's some people do it with Wikipedia. I do it with case law. Anyway, so a couple things. First of all, the claim. Yes, I'm aware it's a terribly worded claim. No, I don't think a 12b6 motion, that's the failure to state a claim upon which relief can be granted, I don't think it's going to fail due to that. I think they've stated sufficient claims that it should go to trial on. Do I think that there's going to be a motion to stay or a motion to dismiss pending the criminal proceedings? Yeah, he's making a lot of claims about unlawful arrests and things like that. And if the actual arrest turns into a conviction, that is pretty solid evidence that the arrest wasn't unlawful. So, yeah. I'm hearing that that non-attorneys, that the actual auditors in some capacity wrote the complaint and that he just signed off on it. That would be shocking to me. I can't imagine that being really a thing. I would be taken aback. Again, you know, the more I see of the world, the less shocked I am of some of the stupid stuff that goes on in it. But that would still be somewhat shocking to me. I am surprised that he would file it in the condition it was in. It does seem like, well, you do get one chance to amend it as a matter of right. And you can ask to amend it again further times. And if justice demands it, or if the other side agrees to let you, then yay, hip hooray, you get to rewrite your complaint. I don't necessarily think that just writing it shitty the first time and relying on your one free right to amend is a solid plan going into it. But, you know, what do I know? I'm told that Mr. Radner is famous because he did the Pulse nightclub lawsuit. He did. Yeah, so I looked that up just before I started doing this. Because, yeah, I read cases and articles and stuff while I'm walking, because what could go wrong? Anyway, he just filed it on June 7th. He's representing the survivors, and he's suing the police and the city over negligence. And if ever there was a Hail Mary shot in the dark, it's that. You may have remembered, I've gone over videos about the duty to protect, and I don't think he's gonna go very far. I haven't read that complaint, but yeah, I'm assuming it's a 1983 sort of lawsuit, although it did say negligence, so maybe there's some sort of negligence theory in Florida. You may wonder what he's doing in Florida, as would I. Apparently things aren't quite busy enough in Michigan to suit his purposes. So I don't know where I was going with that. Yeah, I'm not entirely sure that that's really something to strike a feather in your hat over, is that you're currently engaged in another, what is likely to be a big lawsuit. I would bet the Pulse nightclub shooting lawsuit, where he's suing the city and the police, I'm going to bet that he's hoping for a settlement. Because I mean, suing the police, it'd be stupid. We've gone over the no duty to protect. The police had no duty to protect these people. The police have discretion in how to allocate their resources and their units. And I think they'd have to prove that the police getting there, the police could have gotten there sooner, after they said that they had units on the way, that they could have gotten there sooner and somehow saved some of these people. And I'm not entirely, I just don't see it. It's just a pretty craptastic case. I mean, I'm not saying that what happened at the Pulse nightclub was somehow good. I'm not on the Pulse nightclub shooter side. I'm not even on the police's side in that instance. I'm not on a side. I don't have a horse in that race again. And I'm just saying it's a terrible, like, it's certainly not the slam dunk lawsuit that one would hope for. It is a probable loser. And again, if he can get a settlement, he should really take it. So that's kind of where I'm at on that, on the Leon Valley complaint still. Yeah, I'm gonna, with the first complaint, with the original complaint, not even an amended complaint, I don't know what's gonna happen. It's really, a lot of it's gonna depend on how the city and the lawyers for the individual officers are going to choose to respond to it. They do have quite a bit of time. The complaint was filed. We don't even know when the officers will be served. They have a long time to do the service of process. I think at this point, before they've even served, I think they can actually just withdraw the complaint without there being any prejudice against them in any further proceedings. I'm not having the federal rules of civil procedure in front of me and not really playing around in federal courts. I'm going on bar memory, but I'm pretty sure that until they've served somebody, that they can, ooh, that would be interesting. What if the police claim that they've been served by publication? That would be interesting. Oh, that's a homeless guy. I don't know what that homeless guy was doing, just chilling on the street. And my dogs are doing their best to wrap me up. You're like a homeless guy in a car? Okay, so he doesn't have a home, but he has a car. You could be homeless in a car. I see it a lot out here. Anyway, the next fun step in our little talk this morning is going to be burdens of proof. Over and over again, I have more than met my burden of proof on the claims that I've made. You've got Ed putting out solid work right now, again, showing case law, showing how it applies to the CFR. In his video this morning, or maybe he put it up last night, I don't know. He's going over poster 7 yet again. because people just refuse to believe the truth. But he's pointing out how Congress did give the post office rulemaking authority, and how Congress did allow for there to be actual punishments for violations of those regulations. So these rules are laws, these laws are rules. You have to abide by them. You expose yourself to liability if you don't. And over again, my side, or at least I, provide links to case law and things like that. If you don't want to believe, that's fine. But if you're going to tell me that I'm wrong and you don't cite any case law or anything that's actually showing that I'm wrong, I mean, I appreciate you and I appreciate your opinion and I fully support your right to state your opinion, but I'm not going to believe you for 1 minute because you're not writing a Supreme Court opinion, or any court's opinion for that matter. So I'm just curious why all of these people out there want to believe that they're right when they have nothing to support their position except maybe Felipe hemming and hawing over how Poster 7 does or doesn't apply in whatever mood he's in, or over his little lackeys who echo his words as though they were gospel, or the other auditors who similarly have no experience in the legal field other than as defendants. You got to start wondering at some point in time what gives them a greater knowledge than the judges or the lawyers or the legislators who are writing these laws. You may want to discount lawyers. You may want to discount judges. But at the end of the day, it's the judges who interpret the law. You may not agree with that. You may think they're doing it wrong, but they're the ones who have the ultimate say over what it is, not you. Your opinion is meaningless. Their opinion is meaningful. And lawyers, we, better or worse, we're trained to have some understanding of how the law works, how these various rules interplay with each other. I got a ration of grief from Billy of Occam, who loves to argue, and that's fine. Getting on me about adding the word only into 602.1d. Well, it's in there whether you want it to be or not. It's a standard kind of thing. The example I gave him is if you point a gun at somebody, if you only point a gun at somebody without anything more, depending on state law or whatever, you're guilty of assault with a deadly weapon. Pointing a gun at somebody is assault with a deadly weapon, generally speaking. Your state law may vary. If you pull the trigger, it's no longer assault with a deadly weapon. Because assault with a deadly weapon is if you only point a gun at somebody. As soon as you pull the trigger, it becomes attempted homicide or homicide. It changes the nature of what has happened. If you're only exercising your constitutional right and you're not doing anything additional, like causing a disturbance, then that section D would apply, D2. Because it's there to protect you from being targeted based on the constitutionally protected activity. But the fun thing is that they didn't even have to put that line in there. We're talking about 602.1D2. That's California Penal Code. That's the intentional interference with the business by intimidating or obstructing or things like that. So if it was only a constitutionally protected activity that you were doing, even without that D2 in there, it would be constitutionally protected. And the Constitution, either of the state or of the federal government, would trump that law, and it would not be allowed to be enforced on it. So it's really a meaningless little phrase in there. But this is just going to the difference between lawyers and non-lawyers, is that lawyers understand that, and we read things in where they're not necessarily written because we understand how it's applied. Anyway, my dog's desperately looking for a spot to make biscuits. Oh, here we go. All right, he's making biscuits, and I'm gonna have to clean it up. I need 2 hands for that. Thanks for watching. Have a great day.